Good morning. See, the advocacy depends upon application of mind, consolidating our knowledge in law. And if any question arises, we have to go through the entirety of the act, and the challenge posed by the other side should also be considered. Then only you can develop as a lawyer who go ahead. If you aspire for elevation, definitely you will reach. That is law of interpretation, construction, doctrine of reading out. Reading out means you have to read certain provisions and make the judge understand in a different way. That is doctrine of reading out principles. Here, a fantastic case I would like to discuss with you. Probably you may not come across that case. Here, what actually happened? The case was filed for marriage, divorce on the ground of mutual. Then mutual divorce was granted. Then what had happened? That was challenged in way of appeal. They say under section 96 of the CPC, class 3, since the mutual consent is a degree of compromise, appeal may not apply. This is what they say. But you see, under what circumstances this was get over by the other side. This is judgment A, or it was held that mutual consent divorce is not degree of consent, degree of compromise. Therefore, they say section 96(3) not attracted. How they have interpreted that, you must understand. AR 2022 Punjab and Haryana Division Bench Judge Navdeep Singh versus Sprinka, section 13B 23 96(3) were discussed. They say, however, very soon better sense prevailed in the couple and they have united together. They are present in court today and give their Aadhaar card, copies of which are tagged. On a specific query put to them, they submitted they were living together along with their mother. They seek set aside the judgment degree dated so and so. But I do not know how this was objected to. Then they say an appeal against the degree of divorce by mutual consent distinctly is not merely on consent of parties, for the matrimonial court is involved in a decision making, so that it occurred not only with the provision of section 13B of the Act, but also section 23 of the Act. In subsection 13B of the joint petition by the spouse can be presented to the district on the ground that they have been living separately for so and so, so and so. So they say then the waiving period of 6 months. Section 23 in particular subsection 1BB that such consent has not been obtained by force, fraud or undue influence. Thus, a degree for divorce by mutual consent is not based merely on mutuality of the consenting party, but the court involvement in decision making is inextricably a part of the degree. And since the possibility of an error, legal, factual, entering in the decision making cannot be ruled out, an appeal under section 28 of the Act has advisedly been provided. Therefore, section 12 of the Act says that subject to other provisions contained in the said Act, and to such rules, and the High Court may make in this behalf as proceeding under the said shall be regulated as per may be by the Civil Procedure Code. So they have held. See, they what they say is, you try to understand. What they say is, when you compromise some suit and obtain a degree, that means the court has no say at all. But when you file a petition under section 13B for consent degree, the court has to look into certain aspects as stated under section 28 and as well as 23 of the Act, application of judicial mind. Therefore, this court had rightly held that the divorce under mutual consent is applicable. Therefore, concentrate on this case is somewhat seems to be very strange that after getting mutual consent degree they have started living. That is for what they got mutual consent, I do not know, whatever it may be. But my concentration is only on the question of interpretation, how this provision of bar under 96(3) was get over. Kindly go through this, be armed with this judgment. Then another question, I want to trouble you again. Another case, this is what they say you should be very careful. Normally, do not encourage the client's relative, father, mother, brother, whoever they may be. You have some preliminary consultation with them, but only you discuss directly, secretly, not secretly, alone with the wife or husband who want to file divorce or whatever may be the matrimonial cases. For this I reason that if whatever they say, if you aware in the petition, subsequently if it is not proved, your client will be in problem. Here in AR 2022 Calcutta 219, Kishan Chand Modak versus Avabhadra Modak. Therein, the wife alleged that the husband was living in extramarital relationship, he extorted money, attempt to forcible termination of pregnancy, denial of food. These things are clear case of cruelty because she failed to prove this allegation. Therefore, mind it that when at the time of filing or drafting, you should command them to have some proof, and you should be shy because you are the first judge of the client. You must compulsorily test her whether her allegations or our statement could be proved or not. Best wishes.